G'day, I'm Stephen Page from Page Proven Family and Fertility Lawyers. And one of the things I've been talking about lately is the 10 lessons I've learned about surrogacy since 1988. So a recap, my first surrogacy case was way back in 1988, maybe before you were born. And since then, I've advised, as best I can estimate, in 1,968 surrogacy journeys for clients throughout Australia and at last count, 38 countries overseas. So this is video number 3 in the series, and this is the human rights of all concerned should be protected and there should be binding contracts. In 2018, the then UN Special Rapporteur for the who was obviously against the exploitation and sale of children, came out and said, look, there should not be binding contracts with surrogacy because the surrogate is always the mother. Well, I have a fundamental problem with that because being a lawyer, I like certainty. The UN Special Rapporteur said that having binding contracts in effect amounted to the sale of a child. I certainly don't agree with that. And we see binding contracts in a whole variety of countries to do with surrogacy. For example, Canada, an altruistic regime, the United States, South Africa, for example, Greece. So in these countries, we have these contracts, and on the then Special Rapporteur's view of the world, therefore that amount of sale of a child. What I see as a lawyer is that you don't have the risk associated with a capricious surrogate or malicious surrogate who says, well, I've had the child now, but guess what? I'm not handing the child over. And the standout case to me was a case decided called Cedo and Poon in Australia in 2021, where the surrogate was a traditional surrogate, and she was a friend of the intended mother. So we had two heterosexual couples, husbands and wives, and they came together and she said, okay, I'll be a surrogate, but please give me some money, a few $1,000 to enable me to get Australian citizenship. And they tried it first with the intended father having sex with the surrogate 4 times. That didn't work, so then the intended father and the surrogate went off to the IVF clinic pretending that they were a couple. And his wife, the intended father's wife, the intended mother, was also there as a close friend. So no written surrogacy agreement except some handwritten scratched notes between them and notes via WeChat. But in any event, the IVF worked, 2 children were born, and then the extortion attempts commenced. No handing over unless there's steadily increasing amount of money, until finally a lawyer wrote a letter saying, mindful of reasonable expenses under the New South Wales Surrogacy Act, which of course bans commercial surrogacy, given the expenses that have been incurred, my clients need to be paid $300,000 Australian, but as a special favour to you, we'll accept $290,000 paid within 7 days. Just an extraordinary amount of money. And how did that all come about? Well, because there's not a binding contract. You have a binding contract in place, and it's very clear, if you've got protection of human rights, who is going to be the parent at what stage, whether it's a preconception order as you'd have in, say, Greece or Israel or South Africa, or a pre-birth order as you might have in the United States or certainly some parts of Argentina, or it's a post-birth order as you have in some parts of the US and in Canada. But having that binding contract makes plain who is a parent, makes plain who's the child's parentage, and also makes plain that if you breach it, here are the consequences. So I don't agree with the UN Special Rapporteur. In my view, having a binding contract gives legal certainty. Everyone going into this deal knows what their role is. And typically the surrogate, who is a gestational surrogate, who has no genetic link with the child, knows this is her role and it's her obligation to hand over the child. So she should be protected, her partner should be protected, the intended parents should be protected, any donor under any donor agreement should be protected, and above all, there should be protection, human rights and certainty of contract to the child. Thank you for watching this video. I'm Stephen Page from Page, Provan Family and Fertility Lawyers.